Hi friends from around the world. This is about big business today. This is a business channel, and although it is a business channel about Europe, I would like to talk about Pfizer and Moderna. Well, Pfizer is also partnering with BioNTech, which is a German company, so there is a certain European angle as well. You know, the Pfizer and Moderna, they made the COVID vaccines, so it is big business. It was big business for them. And here we want to revise a bit something of a business angle and something from the IP angle. Now, from the business angle, we know what a patent is, right? A patent is something which gives you a kind of monopoly to exploit it over some 20 years. An invention, it must be an invention, industrial application. So we know that the 20 years is a kind of reward, a monopoly, a financial reward for the heavy investments you have to put in order to make the invention, well, going live happen, so to say, and for the also the kind of financial investment you have to make for the patent application and patent maintenance. So you have still in the medicine, the healthcare sector, and the vaccine sector, you may still have to face heavy risks, business risks, right? So that are business risks like for a vaccine, normally it's about 10-year development you need to do. That is a heavy investment, but also a heavy timeline in order to manage it within your business cycle. You have a certain responsibility with regard to vaccine side effects. The cost of the R&D is very heavy, and you have the risk whether you can recover it through the patent exploitation afterwards or not. The speed of development vaccine, so 1 year to 10 years, is the 10 years is a very heavy one. So, and if you can sell the vaccines, that's another business risk for the vaccine maker, so to say. How was the situation here for Pfizer and Moderna? And I want to make a difference on what a real business case is about, although a bit special, I would say, and the normal risk situation a new patent owner would have to bear. Now, in that case, the cost of R&D was mitigated for Pfizer and Moderna, probably for the others as well, but I will focus here only on Pfizer and Moderna for the patent litigation, to which I will come after. Now, Pfizer and Moderna, they partnered, so to say, with health agency, government agency of the US in order to get some funds be released, which will go into the research and development, and then will come as an end result into the patent. So the business risks was not fully absorbed by Pfizer or Moderna. Then you can imagine that if some public funds goes into the research and development, that the approval of the vaccines will be some kind of smooth. It will be smoother than if somebody comes from, totally outside the health agencies. The speed of development of the vaccines, which is normally 10 years, as I said before, so it has been reduced in that case to 1 year only. And responsibility, which is another risk, so, the side effects of the vaccines, heavy risk. In that case, it was so to say, taken away from the government and assumed by the government itself, not only by the US government, but also from governments from around the world. So, and the success of the vaccine, so the sales and the final business result is also a business risk. You don't know what normally happens within 10 years, whether the risk for which the vaccine was produced is still there. Well, here it was only 1 year, but even though the success was assured from beforehand, because the contracts were made before the release of the vaccines with the governments, and the governments, they compromised to buy, billions of vaccines before production even. So it was a sweetheart environment, I would say. That is not an environment a normal patent owner would face when he wants to apply for a patent, so namely a startup, so a small business. There are some disturbing facts as well. One would be that I learned that it is normal in the US that some royalties would fall back to the employees or scientists of the US health agencies. It was for, what was it, $130 million US for a 5-year period or so. So it was a substantial amount which flows back. So again, this smoothes the relationship with the approval agencies. The cost of the jabs, well, this is something which is a bit disturbing for me. The cost of the jabs is not well known, is not known at all, I would say, to the public. I didn't find that one, because the contracts are concealed or blacked out to a point where you don't know exactly what was the contract agreement between the parties, so the government and Pfizer and Moderna, and the companies wouldn't say anything. Well, but let us go to the patent proceedings now. The patent proceedings between Moderna and Pfizer. It was initiated by Moderna already some time ago in an civil infringement proceedings against Pfizer. So it is about messenger RNA, right? This is at the core of the patent, and this is what the vaccines are about. There's a novelty which brings, a message to the cell, and that message will then reproduce some antibodies and so on. Well, I'm not a technician here, I'm not a medical, but that is what I understood what it's about. But it doesn't matter here. So they brought initial proceedings against Pfizer for infringement of the Moderna patents, which is, well, the normal way the patent litigation will start. And then the second part is also a normal way the defendant would defend itself against such a litigation. It was a second lawsuit which was brought by Pfizer against Moderna, so the vice versa, for the invalidity of the Moderna patent. So the Moderna patent lawsuit is based on a patent, and the defendant is saying, well, that patent which Moderna is based on is invalid because it is not the state, it was not at the moment of filing the state of the art. And Pfizer says, well, that is already from the 1990s or so, where messenger RNA was developed, and they refer to a certain Robert Malone, to which I will come a bit later. So this is even the big ones. So this is a big lawsuit. The big ones will defend in a classical pattern, so infringement and invalidity lawsuits about that. How will that end? I don't know. The big lawsuits, there's a heavy amount involved, as you may imagine. There is witnesses, there's technicalities. I didn't go into that one. It doesn't matter here. I can only imagine that it is highly complicated with one and the other filing, and that makes it complicated. And the end result will be probably, as it not always, but many times go there will be an agreement between the parties, and the final beneficiaries will be the lawyers involved. Now let's come, as I said before, to Robert Malone. He is apparently, well, he claims to be the inventor of the messenger RNA in the 1990s. He was never employed by Pfizer or Moderna or any other big actor of the vaccine manufacturers at this moment. It was a company in California. Don't mind the name. Now, he was a research fellow in that company, and I don't know what kind of arrangement he had with that company, of kind of contractual arrangement he had, whether he is working on a new product and what will be the IP destiny of the result of his work. That was not probably not be arranged or not be arranged in his favor. He says he is the claimant of the messenger RNA, but he doesn't have any financial advantage out of it. So it may be that he get a reputation somehow back if the Pfizer invalidity claim against Moderna is being, so to say, successful. The Moderna patent would then be invalidated due to the previous research, probably that one of Robert Malone. Now, let me wrap this up for you. Well, the first thing is if you are doing business in the regulatory environment, where the state is involved in your business venture and the success of your business venture, well, stay close to them. Make royalty payments if that is possible in your legal home jurisdiction. If not, stay away from them. But the keeping contact is an important issue for avoiding future problems. The state of art, well, that is another issue you should closely follow and go into a risk, but willingly, knowingly, not knowingly. That will be a bad surprise afterwards. And then the normal proceedings, infringement and invalidation, well, that happens at all levels. So it is not something which is only for the small guys here, for the startups. No, it happens at all levels as a classical pattern. You can apply to your situation as well. And if you are an employer in that business, or you are employed, well, the agreement you make with your employer or with your employee, if it is the case, you try to take advantage of your position if it is possible and the other willingly signs up to, but at least try to obtain a fair agreement, a fair shared balance agreement with the other party. So that's it. Thank you for tuning in.